Hello, I'm Ralph Curtis, and this is Andrew Mendlin, my partner, and we're with Curtis Legal Group. And today we're here to talk about if you slip or trip on somebody else's property, what are your rights? Andy?
Well, if you slip or trip on somebody else's property, then you may have a right to go against the property owner, who could be the landlord or the tenant as well, or you may be able to go against the property manager. All those that are responsible to maintain that property may bear liability to you if you're injured and you trip and slip on somebody else's property.
Now, does the reason that you tripped or slipped, does that have to be a certain category? In other words, a small defect in the property or a big hole, or how does the law apply to that?
That's a good question, Ralph. It actually has to be an unsafe or dangerous condition. A trivial defect, a minor defect in the property is not something that the law would expect a landlord, property owner, or tenant to fix or protect against. So in those situations, the landlord, property owner, property controller won't be held liable in those types of situations.
Yeah, there's also the concept that the owner of the property has to be aware of the defect or the dangerous condition. Obviously, they can't protect against something that they don't know about. Or they should be on notice of it, whether they are aware or not. If it existed for a long enough period of time that they should have known about it, then they can also be responsible. Is there a concept of warning of these kinds of conditions? What if Andy, the condition on the property is such that it can't really be fixed, but it's important that people be allowed to be in that area? Is there some concept that the landlord or the owner of the property has to warn of the defect?
Yes, there is. It's a very good point. And many landlords and the tenants and others in control of property will argue that, well, they couldn't do anything about the defect or the unsafe condition. Nevertheless, the law says that you have a duty to warn. You need to put out a warning sign. You need to do something. You need to stand by the defect. You need to do something to warn the pedestrian or the guest upon your property that, hey, there's an unsafe condition on the property and you need to do something about it. You need to protect yourself. You need to watch out. There needs to be that. So either you fix it or you warn.
That's true. And there's also the concept of what we call comparative fault. In other words, you have to kind of look out for your own safety as well. So you have to watch where you're going. You have to be aware of your surroundings. And if you walk right into a large pothole without paying attention, you could be responsible to some extent for your own injuries. So take that to heart. Make sure you know where you're going. Anyway, if we can help you with any case such as this or any other type of case involving injuries caused by the negligence or fault of others, please give us a call. We're Curtis Legal Group.
Call 1-800-LAW-3080.
The heavy hitters.